Hi, it's Roland Jones. This is another short video in a series on preference and fraudulent conveyance issues. In this case, the court faced an interesting question. It's a wrinkle in the ordinary course defense. Payments were actually faster, were being made faster during the preference period, and significantly faster than payments that were made during the so-called comparison period or base period, roughly the year prior to the preference period. So the court's job is to take a look at how business was done during the preference period, the 90-day period prior to the bankruptcy, and compare that to another period, a base period, a year prior or a different length of time, but to compare the two periods and see whether payments during the preference period were ordinary. In this situation, what happened was that the vendor was actually this was a construction project, and the vendor was paid significantly faster during the preference period. And the court heard testimony and looked at evidence, and what appeared to be the case is that the vendor had specific credit terms that it set out in its contract with the company that would eventually file for bankruptcy, and the debtor was attempting to remain within the credit terms as set out in the agreement. But the result was that the debtor was paying a lot faster. So the issue for the court was, well, you know, the debtor was paying faster. Otherwise, the vendor is going to stop working, stop supplying building products. And the question is this enough to take it out of the ordinary course? This threat that the vendor would stop providing a product, which typically would take it out of the ordinary course. So those are the two positions. And the question is, what's the court going to do here? It's a real cliffhanger here. This is the applicable statute, and this is the section that we're looking at, 547C2A. Was this because payments were faster, because the debtor had to stay within the credit limit, or not be shipped necessary products? Was this in the ordinary course or not? Drum roll. Well, the court did decide that it was within the ordinary, that the payments were within the ordinary course, and looked at the history of the parties and found that the credit limit was merely an agreement between the parties that existed during the base period and the preference period. It wasn't changed. There wasn't a different credit limit, and that there wasn't unusual collection activity. And the fact that there was a credit limit and that the debtor was making faster payments to be within that credit limit is not enough to take the transfers out of the ordinary course, and so the defense did apply. So, you know, what do we take away from this? What we take away is the ordinary course is very fact specific, and that even though the payments were made much quicker than normal, and that was different from the base period, it's not enough in this case to take it out of the ordinary course. It's really going to depend on how the facts play out, and in this case, the fact that there is a credit limit and payments were made to be within the terms of the credit limit is not enough to take it out of the ordinary course. So it's useful to know that.